Now I invite our chief guest today, Dr. Rajender sir, to give on a few words on role of judiciary in Telangana.
ముందుగా మీ అందరికీ తెలంగాణ రాష్ట్ర అవతరణ దినోత్సవ శుభాకాంక్షలు. రెస్పెక్టెడ్ dignitaries on the dais, Mr. Professor Venkateshwar garu, Head of the Department of Law, and Madam Radhika Yadav garu, Principal, University College of Law. I deem it privilege to address you on this occasion of celebrations of Telangana Dashabd Utsaval. Now coming to the topic assigned to me is the role of judiciary in India, more particularly relating to the Telangana state. Going too further, I will put two words because the situations prevailing in the country, what it says, whether judiciary is responding to the needs of the people or not, number one, whether the people's expectations are more from the judiciary. Okay, I will quote what the one famous person said, I can guarantee freedom of speech. I can guarantee freedom of speech, but I cannot guarantee freedom after speech. I cannot guarantee freedom after speech. These are the words. Now, likewise, the judgments of the Supreme Court. Now, recent trend of the Supreme Court. What it says, I can guarantee freedom to come to court. I can guarantee freedom to come to court, but I cannot guarantee freedom once you have come to court. This is the situation prevailing in the country. But I am sorry to say these are the state of affairs. But anyway, now we'll go through what are the other aspects. I don't know whether you will release my speech or not, whether I am going to be deep or not. Otherwise, I will cut short my speech before going to that. Whether judiciary is having independence or not, whether judiciary is following its norms or not, whether the appointment of the judiciary is, whether the judiciary is responding to the needs of the common man or not, whether to whom it is responding, only to the higher-ups or have-nots, hives or have-nots. That is the only difference between. And డబ్బు ఉన్న వాళ్ళకి రెస్పాండ్ అవుతుందా, డబ్బు లేని వాళ్ళకి రెస్పాండ్ అవుతుందా, అధికారం ఉన్న వాళ్ళకి రెస్పాండ్ అవుతుందా, అధికారం లేని వాళ్ళకి రెస్పాండ్ అవుతుందా? These are the questions coming to what I am making an effort to make this. Okay. Further going to that, before going to, because you are all law students, therefore I want to make a mention. What are the salient features of Indian legal system? What are the salient features? The salient features of the Indian legal system are existing today. The Constitution guaranteeing fundamental rights permit the entire law. A federal polity, Sunderland state, which however has not affected the organic unity of the legal system. Recognition of precedent as a source of law and thereby keeping in India with a common law family. Existence of comprehensive courts on several topics, lawyers and law. Advanced system procedure. Next coming to lastly, what is the rule of law? That is what ultimately what we are expecting from the courts. We are expecting from the courts or from the state only the rule of law. Nothing more. What is meant by rule of law? There are several criticisms on rule of law. That is only for the purpose of rule of law. We should see Article 13 of the Constitution of India. What Article 13 of the Constitution of India says? So fundamental rights are paramount and override all rules of law inconsistent with those rights. That is the Article 13 of the Constitution says. Now coming to what are the sources of Indian law? What are the sources? Number one, legislation, including delegated legislation, case law, we call it as a precedent, and custom. These are the sources of law. Now coming to two bodies in India, they are making the law. One is the parliament and number two is the state legislature. Now in brief, what is ordinance, what is delegated legislation, you might be taught in the law colleges, but I don't want to go into those aspects, but directly I will go to the topic of whether judiciary is independent. Whether judiciary is delivering the judgment according to their conscience. Is it possible to deliver the judgment according to the conscience? Now we have to see from the origin of the, from prior to the 1975. Prior to 1975, that is prior to the promulgation of the emergency in India. What happened in India? Indira Gandhi's election was nullified by Allahabad High Court. At Allahabad High Court, on June 12th, we are also in June 12th. June 12th is the significant year, and coming 26th is also a significant date. Emergency was promulgated in the year 1975. Therefore, on June 12th, 1975, High Court, the Allahabad High Court delivered a judgment saying that unseated Mrs. Indira Gandhi, she is not eligible for an MP. That was the judgment delivered by none else than the judge is the Sinha. Justice Sinha delivered the judgment. That is Jagmohan Lal Sinha. His age is 55 at the time of pronouncement of the judgment. He arrived to the court at 9:55 a.m. Room number 24 was jam-packed. A 258-page judgment was delivered by him, which he wrote despite all obstacles. There are several pressures on him, but he delivered the judgment. The petition is allowed. That is the only word he said. The decision is stated. The petition is allowed. The news immediately received by the NK Session, who was available in the Prime Minister's PMO office, and the Prime Minister was informed about the decision, whether to resign or not. That is the question before the Prime Minister. Ultimately, there was a lot of demand from the opposition leaders for the resignation of Srimati Indira Gandhi, but it was not done. And ultimately, what Indira Gandhi did is she promulgated that is what the emergency was promulgated. That is the first judgment delivered by a judge against the most powerful person of the country. She was the most powerful person of the country in India at that time. That is Indira Gandhi. She was unseated, but he was not aware of whether the how the things will go on. అదంతా కూడా ఊహించలేదు ఎట్లా పోతుంది అని. But the judgment was delivered. Thereafter, what happened? Emergency was declared on 25th June 1975. President exercised his definition power, and what happened? Including the fundamental rights were taken away after the proclamation of emergency. Is it correct or not? That was the question again. That is the famous judgment, ADM Jabalpur versus Patil. That is ADM Jabalpur case is a very famous case where 1 out of 5 judges, the constitution bench, out of 5 judges, only 1 judge given a dissent view about the fundamental rights. Article 20 and 21 cannot be abridged, cannot be taken away, even after the pronouncement of the emergency. That was the decision, dissent decision given by 1 judge. That is the other 4 judges are A.N. Ray, Hamidullah Beg, and P.N. Bhagavati. Justice Ravi Chandrachud, the father of our Chief Justice of India, held that with the proclamation of emergency and subsequent suspension of the enforcement of Article 21, no writ lies in court against detention of any person. That is next. What happened? Because of this judgment, he paid a lot of price. He is in the road to become Chief Justice of India, but he was overlooked by the government of India, and the junior most person was given elevated as the Chief Justice of India. But he didn't bother about non-elevation as the Chief Justice of India, but he resigned thereafter. That is, his name is H.R. Khanna. H.R. Khanna, if you go to the Supreme Court, you will find this portrait in court number 2. No every portraits undav Supreme Court lo. Only 1 portrait that belongs to H.R. Khanna will appear on the wall of the second court of the Supreme Court of India. That is the respect given by the Supreme Court to H.R. Khanna. We forget so many people, so many judges, but we don't forget H.R. Khanna. That is because of his judgment. Even though he knows that the things how it will happen, but he didn't bother about it and he delivered the judgment. That is the HR Khanna. Thereafter, listen to you. Anyway, this is the second judgment where the judges raised according to the occasion, and thereafter we will go to another judgment.
Thank you.
Recently, what happened? You might be going whether you are following or not, but this another judgment is the judgment given by that is the judgment in Harish Chandra Rawat versus Union of India. Harish Chandra Rawat was the Chief Minister of Uttarakhand. The Congress had mustered uneasy majority of Uttarakhand legislature in the year 2016 elections and had come to power in the state with Rawat as the Chief Minister. The Congress held a majority of 36 seats, only 36 seats out of 70 members. Therefore, thereafter the BJP as its nearest rival with 28 seats. After the passage of the appropriation bill, 9 Congress MLAs switched sides and joined the BJP MLA to submit a joint representation to Governor K.K. Paul demanding the dismissal of Rawat ministry. Dr. Paul wrote, why I am mentioning this judgment? Because the judges are raising to the occasion or not. This is another incident. What Dr. Paul wrote to the Chief Minister, it was agreed that the latter would call for protest on March 28, 2016. In the meantime, proceedings under Schedule 10 of the Constitution were commenced against the 9 MLAs. These disqualification proceedings were to commence on March 27, 2016. The 9 MLAs moved to Uttarakhand High Court on March 25th, questioning the deferment of the disqualification proceedings. These petitions were, however, dismissed, finding that the dissident MLAs did not get any relief from the High Court. The Union Cabinet swung into action. Thereafter, what happened? The Union Cabinet swung into action and called for the imposition of the President rule on March 27th. Purportedly, on the basis of the sting operation video, which allegedly showed Rawat engaging in horse trading. The effect of this was a double hitting at the authority of the governor's decision to hold the floor test and cloud the authority of the speaker to adjudicate the disqualification proceedings under the 10th schedule. Chief Justice Joseph, now the role of the Chief Justice of Uttarakhand. What the Chief Justice Joseph began by observing that the invocation of Article 356 ought to be seen in the larger canvas of the federal polity of India. The soul of the matter, said the Lord Chief Justice, I quote, is whether in the federal quasi-federal setup it is open to the central government to get rid of the state governments, uprooting the democracy elected governments and introduce the attendant chavos in the system, undermining the confidence of the little man who stands with little paper, little white paper, in the words of Sir Winston Churchill, to cast his precious vote battling snow, the scorching heat and the rain, finding that the presidential proclamation was founded on materials that wholly extraneous. The court fashioned the same with an observation that the adopting of democratically elected government breeds cynicism in the hearts of the citizens who had participated in the democratic process. It undermined the foundation of the federalism. That was the judgment delivered by Mr. Joseph. Thereafter, what is the memorable passage of the Justice Joseph observed? He carried out the policies ordinarily in accordance with the manifesto, which parties may take to an electorate, is an important function which is to be carried out by the persons who are elected. They stand in the danger of being worsted at the hustling should they fail before people during the time. This is what the Supreme Court said. The judgment of the what is the price paid by him by delivering the judgment? He requested for the transfer to the AP High Court. At the time, United AP High Court was there. the government of central government, the government of India was not obliged to transfer him, even though there was a recommendation by the collegium, he was not transferred. Ultimately, he was given another place, and his name was recommended to the elevation to the Supreme Court along with the another lady of the Supreme Court, but that advocate lady, Indra Malhotra. Indra Malhotra was elevated, but he was not elevated. After that, Justice Mishra, who threatened the central government that he will resign if he is not elevated. If he is not, the recommendation of the collegium was not accepted. Thereafter, the government of India accepted the elevation of the Justice Joseph. Therefore, Justice Joseph became the judge of the Supreme Court. However, even though this late, he became Chief Justice. This is the another occasion. Now coming to another person, that is who is Justice Akhil Qureshi. Akhil Qureshi was a judge of the Gujarat High Court, and subsequently he became the Chief Justice. He was recommended to for the Chief Justice post to the Madhya Pradesh High Court, but that was not accepted by the government on some allegations. And again, he was posted some smaller state, northeast state, a smaller state as the Chief Justice of that particular state. And he is supposed to be recommended to the Supreme Court because he is the senior most judge of the senior most Chief Justice in India. But that was not accepted by the government of India for reasons known. It was no collegium meeting was done. That was the price paid. What sin he has committed? The sin he has committed is the collegium rejected the recommendation of the collegium, appointed Qureshi as the Chief Justice of Madhya Pradesh High Court. The collegium instead of appointed Qureshi as Chief Justice of Tripura, a smaller jurisdiction with fewer cases. Among the considerations such merit, representation, seniority place, Qureshi non-appointment caused concerns even the collegium. In 2021, Justice Nariman vetoed all recommendations for the elevation of the Supreme Court for 2 years. 2 years there was no elevation to the Supreme Court. What Nariman said, Nariman was the Supreme Court judge, what he said, unless Qureshi was elevated, his name was considered. There is no question of any person being elevated. That was the stand taken by the Nariman. After the term of the Nariman, recommendations were made by the collegium. Therefore, whether the collegium is powerful or the state is powerful, ultimately it appears the state is powerful rather than the collegium. This is the first best example of Justice Akhil Qureshi, who retires without elevation to the Supreme Court of India. But his name is in the history of the legal history of the. Okay, these are the things. Now coming to what is the trend of the Supreme Court? What is the trend of the Telangana High Court? We will come to that point. What is the trend of the Supreme Court? We will see there are one judgment, National NIA, popularly known as NIA, was versus Jahur Ahmed Shah Watali. This is the judgment whether bail can be given in UPA cases. Now UPA case was also registered against Professor Haragopal recently, and the government directed today itself in the afternoon to remove that, to withdraw that case against Haragopal. But what the decision of the Supreme Court in this particular case, all courts for examining the dissecting the evidence, he effectively made grant of bail in UPA cases borderline impossible. Actively choose a legal position that makes lengthy under trial more likely. Because if you are involved in a case of UPA, it's not easy to get a bail. But Supreme Court is making the judges and the stenographers of the police. This is the comment not made by me. This is the comment made by Mr. Bhatia, who is a famous advocate in the Delhi and also in the Supreme Court. Next, coming to another judgment. Now, he made it, getting a bail in UPA cases is very difficult. We have seen judges who are very much upright judges, and we are also seeing the judges in the Supreme Court who are sailing with the government, not sailing with the constitution. They are sailing with the government. That is the situation. And another case is the PMLA. Now, every day you will see the ED case. ED attached social property. ED has taken steps against so and so property. ED has summoned so and so property. The ED is totally the provisions of the ED is the amendments made in the PMLA in the year 2019 are totally against the Constitution. But the Supreme Court, under the leadership of Justice Kanvilkar, what the Supreme Court said, all are constitutionally correct. That was the decision given by Kanvilkar, and now the revision review is pending before the Supreme Court. Now we have not received any decision on that particular point. That is, I will give one example. Court exempted the police from sharing the incident. Generally, if a case is any offence took place, we will go to the police station, lodge the FIR, and when we receive the copy of the FIR, and accused is also entitled to receive the copy of the FIR. But such type of receiving of FIR, that what is this called? It is called ECIR in ED cases. PMLA, it is called as ECIR. You are not entitled to receive ECIR unless charge sheet is filed, unless complaint is filed in the court of law. You will be examined as a witness, but you do not know what is the contents of the examination. You will confess before the police officer. Confession before a police officer is inadmissible, but confession before the ED officials is made as admissible. What the Supreme Court said, they are not police officers. That is the decision of the Supreme Court. Therefore, any statement given before a ED officials is admissible, but any statement, any confession that is involving confession after 20 clause 3, it is against the Article 20 clause 3 of the Constitution. That was the judgment. ED summons, they will make arrest or they won't make arrest. They will not. They will say the grounds of arrest. It's not necessary to make grounds of arrest. Totally, it is alien to the Criminal Procedure Code. The procedure in PMLA is totally against to the routine procedure in the Criminal Procedure Code. But however, what the Supreme Court said, Supreme Court has endorsed all the amendments made by the Government of India in the year 2019. That is, now coming to how the judiciary is going on. Now we have seen judiciary is going on. Recently, what happened? You might have seen a judgment, but on Allahabad High Court endorsing the hospitals against to the directive principles of the state policy. There should be scientific temper. The state should strive for the scientific temper. What the Supreme Court, the Hyderabad High Court said, there is a dispute between husband and wife. The husband has committed, one male person committed rape against the woman, and woman goes to the High Court, and she demands marrying of that person. He says, no, he is mandatory. Therefore, High Court directed for the astrology of the woman, but however, the Supreme Court interfered and Supreme Court stayed the matter. Now the trend, please see the trend of the judges of the High Court and Supreme Court. This is another trend. And one another trend is that this is one SR said, he is from Meghalaya. What he observed in the judgment, that anybody opposing Indian laws and the Constitution cannot be considered the citizens of India. That's what he wrote in a judgment. Indian laws, anybody opposing the Indian laws and the Constitution cannot be considered as citizens of the country. That was the decision given by SR Sen of Kerala, Meghalaya High Court. Now coming to now another judgment of the Gujarat. The Gujarat judgment says refusal to grant permission to termination of the pregnancy of a girl. Is not a girl, is a rape. She is a rape victim. She is having right to be terminated her pregnancy, but the so-called the Gujarat High Court judge has refused to give permission for terminate the pregnancy, saying that no. What he says, the judge told the girl that 14 to 16 years were the normal age for girls to get married, and by the time they attain 17 years, they would deliver at least one child in her mother's and grandmother's time. He approvingly quoted Manusmriti to support his argument. It is therefore in Manusmriti read. Now we have to follow the Manusmriti or we have to follow the Constitution of India. That is the basic question, which has to be followed by the Supreme Court or any judge of the judge in the country, in the India. What they have to follow? They have to follow Constitution or the Manusmriti?
Constitution.
And now that is the judgment given by the one of the judge of the Gujarat High Court. That was the judgment by the just coming to Akhil Qureshi. This is the trend of the judiciary. Now the question is where we are going. ఎక్కడికి మనం పోతున్నాము అనేది ప్రశ్న. మనం తిరోగమనానికి వెళ్తున్నామా, పురోగమనానికి వెళ్తున్నామా? Are we progressing? Are we not progressing? That is the question before the common people and leaders. Now coming to whether who is powerful, whether the collegium is powerful or the government is powerful. I will give one example for that purpose. In the year, I don't know whether you are following it or not, but these are the things you should see.
Following, sir. Following.
Okay. Because in the month of December 13th, Supreme Court recommended 5 names to become Supreme Court judges. I am repeating, 5 judges names were recommended to the Supreme Court in the month of February, but they were not elevated till the Supreme Court gives a warning to the government of India. That is, they were appointed ultimately on 4th February. How much time it took for consideration of 5 judges to be appointed by the Supreme Court judges? Ultimately, we will see under instance, that is the one advocate from the Supreme Court and Chief Justice of the AP High Court, Mr. Mishra, was recommended for the elevation of the Supreme Court. Within 2 days, their names were cleared by the Supreme Court. What is the reason for delay of 2 months in one case and 2 days in another case? What is this? Why this is happening in the country? Collegium recommended on 16th. It was accepted by the President of India on 17th. They were taken both on 18th. On 18th, 17th itself, Mr. Rijiju was transferred from the law ministry. I don't know the reason. I am informing you. You please see the version. These names were cleared. Names were recommended on 16th, and it was cleared on 17th, signed by the President of India at 6:30 or 7:30, and 8:30, Rijiju was removed. I don't know the reason behind this removal, but this is the situation. I am making a mention. And next coming to what the one of the professor, what he says. He has written a very beautiful book, and he was interviewed by one Bhatia in Baran Bench. What he says, the question, the answer about the collegium system. Well, first of all, recall I will quote. Let us recall that this is taking place in the wake of Supreme Court decision, and that takes back the judiciary back to the judiciary question. Why is the judiciary behaving the way we see it behaving? And I would suggest 3 explanations. One, judges are appointed by the way they used to be, and the collegium system is different. By the way, that was the first reform the Modi government wanted to introduce as early as July 2014. It failed to change the way theoretically on the paper judges are appointed. They are still supposed to be appointed by the collegium, but in practice they are not. That's what I am not saying. It was said by one of the professors, interviewed by one of the leading lawyers in the country, and that was published in Baran Bench, a web journal. This is the situation. Now coming to the courts in state of Telangana. Whether the courts of Telangana are functioning properly, whether the High Court is functioning properly or not, whether the High Court's decisions are implemented or not is the big question. Now coming to long back about in 2021, in 2007, I think 2007, in Prakash Singh case, a direction was given by the Supreme Court about the formation of police complaints authorities. There are no police complaint authorities was established, constituted in Andhra Pradesh and also in Telangana. In the United High Court has given a direction to constitute police complaints authority, but no police complaints authority was constituted. And and ultimately contempt notice was issued. Contempt notice, there was no response, and thereafter a direction was given by the High Court to directing the Chief Secretary to appear before the court. On that night, they constituted a police complaints authority by appointing a judge at the state level and 2 district judges at regional level were appointed along with the committee. A GO was shown to the government, to the High Court of Telangana on paper, but now 2 years have elapsed, but no police complaints authority has been established in the state of Telangana. Now, what steps have been taken by the government of, High Court of Telangana? No steps were taken. I have written 3 articles emphasizing the need for constituting of police complaints authority, but in vain. No, that was not established. Now, that is another situation. Now, the second situation is there are 32 contempt cases against Mr. Naveen Mittal. It appeared about 2 days back. 32 contempt cases against one senior most IAS officer. But why these steps were not taken why the High Court is not punishing? Or why? Now, I am not saying they are punishing. If he has committed some fault, if there is a mistake on his part, he should be punished. Why the High Court is not taking? There are several cases pending against several officers, IAS officers. No steps were taken by the government, the High Court of Telangana. Now then, how a rule of law will prevail? Is it possible to prevail under the rule of law? Absolutely, it is doubtful. Now, another glaring example, about 2 days back, yesterday, not 2 days back, a decision was delivered by the High Court. There was Service Commission members' appointment was challenged by the Professor Retd and it was filed by Mr. Satyam Reddy, advocate. And after 2 years, the judgment was pronounced not quashing the appointment of the 4 members of the Service Commission members, what the Supreme High Court directed. Please reconsider the appointment of 2 to 5 or 2 to 6, whether they are appointed according to the norms provided by the Supreme Court of India in the several judgments or not. If not, you please appoint them and new appointment will take place. But if a Service Commission member is appointed, he cannot be removed by the government. Government has no power to touch a Service Commission member. That is the highest constitutional body in the country. Therefore, they cannot be touched. And that means the government has no power to take any steps except the High Court. High Court can quash. If they are not eligible, High Court can quash the GO, but High Court has not quashed. High Court has forgotten only when the Public Service Commission member can be removed. Only Public Service member can be removed. There should be an inquiry by the judge of the Supreme Court, and the judge of the Supreme Court should give some finding that there is fault on the part of the Service Commission member, and thereafter the government, the President of India, will remove the Service Commission member, not the governor. President of India will remove the public. Appointing of a member of it is easy for the government, it is easy for the Chief Minister of any state, but removal of the Service Commission member is very difficult. What the High Court has given the judgment, only God knows. What is the purpose behind the judgment? I don't know. What will happen about judgment? Simply they will find who have no power to touch the Service Commission members. Therefore, this is the situation prevailing. Now you may be seeing several cases about the granting of the bail, about the remand, about the intervening the investigation process. All these things are happening in state of Telangana, and several lockups are taking place. The government, the High Court or the other courts are not taking serious action against the police officers who have committed the lockup deaths. The encounters have been taken place. Even the one encounter, the matter went to the Supreme Court and again come to the High Court of Telangana, but so far nothing was happening. This is the situation. Whether the rule of law is being followed by in our country or not is a big question. Now these are the questions I am raising. Now it is for you because to think over whether there is rule of law prevailing in our country, more particularly in Telangana after 10 years. It's a 10th year. We are starting the 10th year. 9 years completed. Now we are in the 10th year. These are the things you please think over as a students of the law. Please think over and discuss with your friends and also the professors. This is what I want to say because there is a lot of material is there, but I don't want to take much more time. There was a delay by me for half an hour because of some problem on the topic. In the topic, I will close my talk. I express my thanks to the Professor Retd for inviting me and interacting with you on citation. These are the these are the things I want to tell you. But anyway, if you want to put any questions, I am ready. I am ready to give the answers to you. If not, Professor Retd will close the session. Thank you very much.
Now it is open to the August gathering to ask clarifications, doubts. Please come forward. Yes.
Sir, first, my name is Sabahan sir. I'm LLB final year student from MSS Law College. MSS Law College.
Please.
Sir, the question is not pertaining to this Telangana formation. As your respected judge and you have a vast experience, I want to ask a little question based upon your experiences. So my question is, you being a judge and or else me or else in the future judges, the one who is very loyal, who is totally rigid on the correct path, who don't want to do anything wrong, such kind of judges who are forced by the higher authority to give a wrong judgment, what a judge should do at that time?
No. Generally, there will not be any interference from the higher authorities. Number one, if there is interference, it is not necessary for to abide by the వాళ్ళు చెప్పిన ప్రకారంగా వీళ్ళు వినాల్సిన పని లేదు. First of all, the higher authorities will not interfere. If they interfere, it is not necessary for the concerned judicial officer to obey his orders. Therefore, that is totally, without my experience, I can say that judicial officers are independent to their conscience. Then if he is having integrity, if he is having upright, nobody will touch him. That is this is the only institution where you can act according to your own will. There is not any other service. You cannot act according to your own conscience. But you can act according to your own conscience and within the framework of the law. That is the only judiciary. I can proudly say that I will salute my black coat every day.
Thank you, sir.
So myself, Kumar from Anantala College. Sir, ఇప్పుడు పరిస్థితి ఎలా ఉందంటే ఒక కళాకారుని అర్థం చేసుకోవాలంటే ఒక తోటి కళాకారు కావాలి. కానీ ఇప్పుడు ఏదో అప్పీల్ చేస్తే సరైన జడ్జిమెంట్ రావట్లేదు సార్. వాళ్ళకి అనుకూలంగా ఇస్తున్నారని బయట ప్రచారం జరుగుతుంది. మనీ కూడా తీసుకుంటున్నారని కూడా ఒకటి.
అంటే ఒకటి ప్రచారం జరగడానికి వాస్తవం మనకు తెలియదు. మన ప్రచారం ఇప్పుడు తీర్పు మనకు వ్యతిరేకంగా వచ్చినట్లయితే మన జనరల్ ఇట్ ఈస్ ఈజీ టు కామెంట్ దట్ ద జడ్జ్ వాజ్ బ్రైబ్డ్. యూ డోంట్ నో వెదర్ జడ్జ్ ఇస్ బ్రైబ్డ్ ఆర్ నాట్, బట్ ఇట్ ఈజీ టు కామెంట్. అది కామెంట్ చేయడానికి ఈజీగా ఉంటుంది. ఆ డిలే అవుతుంది అనేది ఒక ఫ్యాక్ట్. కానీ కరప్షన్ లేదు అని కూడా నేను అనను. కానీ ఆ మిగతా వాటితో పోల్చినట్లయితే చాలా లెస్ గా కరప్షన్ ఉంది. తర్వాత రెండో అంశం ఏంటంటే, ఇఫ్ యూ గివ్ ఎనీ కంప్లైంట్, ఈవెన్ ది అనానమస్ కంప్లైంట్ టు ద హైకోర్ట్, ద హైకోర్ట్ విల్ ఎంక్వైరీ టు ద మ్యాటర్. దట్ ఈస్ దిస్ బ్యూటీ is not available in any other department, any other service. మీరు ఒక చిన్న కంప్లైంట్ రాస్తే కూడా దాని గురించినటువంటి ఎంక్వైరీ అనేది మిగతా డిపార్ట్మెంట్ లో కానీ సర్వీస్ లో కానీ జరిగే అవకాశం లేదు, కానీ జ్యుడిషియరీలో జరుగుతుంది. మీరు ఒక ఆకాశ రమణ ఉత్తరం రాసినా కూడా, అంటే జనరల్ గా సైన్డ్ కంప్లైంట్ అయితే ఎక్కువ ఎఫెక్టివ్ ఉంటుంది, అన్సైన్డ్ కంప్లైంట్ అయితే ఎఫెక్టివ్నెస్ తక్కువ ఉంటుంది.
Please come forward.
సార్ నా పేరు రాజ్ కుమార్, 3YDC ఫైనల్ ఇయర్ సార్. సార్ ఏ గ్రౌండ్స్ మీద ఇప్పుడు రాజ్యాంగ పదవిలో ఉన్న చైర్మన్లను కానీ సభ్యులను కానీ ఏ గ్రౌండ్స్ మీద హైకోర్టు వాళ్ళకి అపాయింట్మెంట్ జీవోను క్రాచ్ చేయొచ్చు సార్?
నాకు అర్థం కాదు, ఎవరిని రిక్వెస్ట్ చేయాలంటున్నారు?
ఇప్పుడు హైకోర్టు రాజ్యాంగబద్ధ పదవులను
రాజ్యాంగ పదవులేనా?
సార్ క్వాష్ చేయొచ్చు అన్నారు కదా, ఆ ఏ గ్రౌండ్స్ మీద హైకోర్టు చేస్తుంది?
ఇప్పుడు సుప్రీంకోర్టు కొన్ని గైడ్ లైన్స్ ఇచ్చిందండి. అపాయింట్మెంట్ చేసేటప్పుడు మీరు ఉదాహరణకి సర్వీస్ కమిషన్ మెంబర్స్ అనుకోండి, సర్వీస్ కమిషన్ మెంబర్స్ ఎలాంటి వాళ్ళని అపాయింట్ చేయాలి, ఎలాంటి వాళ్ళని అపాయింట్ చేస్తే బాగుంటుంది అని సుప్రీంకోర్టు కొన్ని గైడ్ లైన్స్ ఇచ్చింది. కాన్స్టిట్యూషన్ ఏమో నామ్స్ లేవు, కాన్స్టిట్యూషన్ నామ్స్ లేవు, కానీ సుప్రీంకోర్టు జడ్జిమెంట్స్ అనేది బైండింగ్ కాబట్టి అది ఫాలో అవ్వలేదు. మీరు ఎందుకు ఫలానా ఎక్స్ అనే వ్యక్తిని అపాయింట్ చేస్తున్నారు, వై అనే వ్యక్తిని అపాయింట్ చేస్తున్నారు, ఒక ఎక్స్ అనే వ్యక్తి దగ్గర నుంచి మీరు ప్రొఫార్మా బయోడేటా ఎందుకు తీసుకున్నారు, వై అనే వ్యక్తి దగ్గర నుంచి బయోడేటా ఎందుకు తీసుకోలేదు, మీరు ఎక్స్ ను అపాయింట్ చేయడానికి కారణం ఏమిటి, ఎక్స్ అనే వ్యక్తి చాలా మామూలు ఉద్యోగి అన్నప్పుడు ఇలా క్వాలిఫికేషన్స్ లేవు అని ఒకవేళ వాళ్ళ ఎమినెన్స్ లేదని కూడా హైకోర్టు అనలేదు. హైకోర్టు ఏమన్నదంటే ఈ నామ్స్ మీరు పాటించలేదు అన్నారు. నామ్స్ పాటించలేదు కాబట్టి రీకన్సిడర్ చేయమన్నారు. నేను చెప్పిన పాయింట్ ఏమిటంటే రీకన్సిడర్ చేసే అధికారం గవర్నమెంట్ లేదు అంటున్నాను. ఒకసారి అపాయింట్ చేసిన తర్వాత గవర్నమెంట్ కెనాట్ రీకన్సిడర్. ఓన్లీ ఇఫ్ దేర్ ఇస్ సమ్ అలిగేషన్స్ లెవెల్డ్ అగైన్స్ట్ హిమ్, ఇఫ్ ఇట్ ఈస్ ప్రూవ్డ్ బై దిస్ in the inquiry conducted by the Supreme Court judge, then only he can be removed. Otherwise, he cannot be removed once he is appointed. ఎందుకంటే పదవి ఇవన్నీ పెట్టారు అంటే వాళ్ళు సమర్థవంతంగా పనిచేయాలి, ఎవరి ఇన్ఫ్లుయెన్సెస్ కి లోన్ కాకుండా ఉండాలని రాజ్యాంగ నిర్మాతలు అనుకున్నారు. అందువల్ల అలాంటి నిబంధనలు ఏర్పాటు చేశారు. అయితే హైకోర్టు నేను అన్న పాయింట్ ఏమిటంటే హైకోర్టు గవర్నమెంట్ పంపించడం వల్ల గవర్నమెంట్ హైకోర్టు యొక్క ఉద్దేశం నెరవేరదు అంటున్నాను. నా అభిప్రాయం, హైకోర్టు అభిప్రాయం ఎలా ఉందో తెలియదు, నా అవగాహన మేరకు, నా అండర్స్టాండింగ్ మేరకు అది నెరవేరదు అని నేను అనుకుంటున్నాను. నా అభిప్రాయం తప్పు కూడా కావచ్చు.
సార్ ఇప్పుడు సమ్ జడ్జెస్ వాళ్ళు పదవిలో ఉన్నప్పుడు గవర్నమెంట్ ఫేవర్ జడ్జిమెంట్స్ ఇవ్వడం వలన వాళ్ళకు కొన్ని రాజ్యాంగబద్ధ పదవులు వస్తున్నాయి కదా సార్, అంటే వాళ్ళు పదవిలో ఉన్నప్పుడు రూల్ ఆఫ్ లా పాటించలేదు అనుకో.
అది కూలింగ్ ఆఫ్ పీరియడ్ ఉండాలని అంటున్నారు కదా. అందరూ ఏమంటున్నారంటే ఇప్పుడు అరుణ్ జైట్లీ ఉన్నప్పటి నుంచి ఆ పద్ధతి నడుస్తుంది. అరుణ్ జైట్లీ అంటే బీజేపీ కాంగ్రెస్ గవర్నమెంట్ ఉన్నప్పుడు, అరుణ్ జైట్లీ బీజేపీలో ఉన్నప్పుడు ఆయన చెప్పింది ఏమిటంటే రిటైర్ అయిపోగానే వీళ్ళకి పదవులు ఇవ్వకూడదు, వీళ్ళకి ఎప్పుడు పదవులు ఇవ్వాలంటే ఒక 2 years 3 years కూలింగ్ ఆఫ్ పీరియడ్ అయిపోయిన తర్వాత అప్పుడు మాత్రమే వేరే పదవులు ఇవ్వాలి అని చెప్పేసి ఆయన అన్నారు. కానీ మళ్ళీ వాళ్ళ గవర్నమెంట్ వచ్చిన తర్వాత అదే పద్ధతి కొనసాగుతుంది. వాళ్ళు రిటైర్ అవుతున్నారు, పిల్లవారు ఇంకో పదవిలోకి వెళ్తున్నారు. అలాంటివి ఉండకూడదు అని చెప్పేసి అందరూ అంటున్నారు, కానీ అది ఇంప్లిమెంట్ చేయడం లేదు అంటున్నారు.
సార్ ఇప్పుడు SC/ST కమిషన్ ఏర్పాటు చేయాలని రాజ్యాంగంలో ఉంది, కానీ కొన్ని గవర్నమెంట్
SC/ST కమిషన్ కాదు, మన రాష్ట్రంలో హ్యూమన్ రైట్స్ కమిషన్ ఖాళీగా ఉంది, ఇన్ఫర్మేషన్ కమిషన్ ఖాళీగా ఉంది. ఇప్పుడు కాదు, మొదటి నుంచి కూడా ఖాళీగానే ఉంటాయి, ఎప్పుడూ అపాయింట్ చేస్తారు. మరి ఎవరు ప్రశ్నించడం లేదు, ప్రశ్నించినా కూడా గవర్నమెంట్ పట్టించుకోవడం లేదు, హైకోర్టు చెప్పినా కూడా పట్టించుకోవడం లేదు. నేను చెప్పాను కదా ఇంతకు ముందు, పోలీస్ కంప్లైంట్ అథారిటీని జీవో ఇష్యూ చేసి కూడా ఎస్టాబ్లిష్ చేయలేదు.
హైకోర్టు సలహాపూర్వకంగా చెప్తుంది, కానీ ఇది
సలహాపూర్వకంగా చేయమని చెప్పింది. దాంట్లో పోలీస్ కంప్లైంట్ అథారిటీలో చేయమని చెప్పింది, లేకపోతే మిమ్మల్ని జైలుకి పంపిస్తామని చెప్పింది. అప్పుడు జీవో ఇష్యూ చేశారు, బట్ ఇట్ వాస్ నాట్ కాన్స్టిట్యూటెడ్ అఫీషియల్, ఓన్లీ ఆన్ పేపర్ ఇట్ వాస్ కాన్స్టిట్యూటెడ్.
థ్యాంక్ యూ.
Outside society, they keep on saying that some malpractices are done in the high courts between lawyers and the judges. Are they really malpractices, or else it is a correct judgment given by the judges?
ఇప్పుడు జడ్జెస్ అనే వాళ్ళు they will live in a isolated place. You don't know what is happening. If they will, advocates will be knowing the result. Generally, they may expect whether they will win the case or not. If it is a winning case, I will bargain with my. There is a possibility of bargaining. I am not saying that all are doing. There is a possibility of bargaining. That means that there is involvement of the judges are there. It is there or not. We can't say exactly. But if there is anything is there, anybody, if you are having any doubt about integrity of a particular judge, you cannot say complaint to the Supreme Court, and Supreme Court will inquire into the matter.
Sir, now in this December 2023, we are going to write CLAT exams. Sir, what should be the minimum marks for getting into law?
I don't know.
Last question.
Okay, so thank you so much.
Then 1, 2, second 2 questions.
Sir, myself Naresh Kadapati. Thank you for your seminar, sir. I am a chemical engineering graduate from IIT. Now I am pursuing the law. Your seminar is really inspiring, sir. How judiciary is strong. Even Prime Minister of the country or the Chief Minister of the state also equal in front of judiciary. The articulation is really very good, sir. And my question is, sir, in your career, like as a judge, would you like to share some of the key challenges you are faced in judiciary and how you are addressed?
No, there is no challenge from the challenges from the parties, not from the higher ups. There is no question of any interference from the higher ups. No judges told me that you do like this, you did not do like this. That was not there in my career of 33 years. Okay, that is number 1 point. Challenge means sometimes one Nexalite appeared before my court and you want to surrender, even though there is no case before me. Can as a magistrate, can I take him to custody or not? These are some type of challenges I faced it, but I successfully did it.
Sir, one more thing. Now rapid advancement in the technologies. Currently we are seeing how 5G technologies or whatever. So how do you see role of Telangana judiciary, like adopting the technologies?
No, there is a lot of progress in the judiciary. Now judgment delivered yesterday, now it is available today. No, mostly judgments are in the net. Anybody can watch the judgment. Now I am telling you, yesterday the High Court delivered the judgment about the flashing of GO issued against the Public Service Commission members. That is available now in the net.
Sir, final question from me, sir. So many law students are here. So out of complete your career, what kind of suggestions would you like to pass?
No. What I will say one thing is, if you wear black coat, you will have the confidence. You can face any challenge. As an advocate or as a judge, it's a very noble profession, good profession. You can earn money and you can help the people.
Thank you, sir.
Okay, what is the question?
So my name is Abhiram from PG College from Brazil.
Okay.
So what are your views on decentralizing Indian judiciary?
Already is decentralized. There is no question of any centralization.
Till now there is
Huh?
single integrated judicial system is prevailing in India. So if any person who is accused who is not granted bail, he has to go on appeals to apex court. So why not the Supreme Court to each state?
Why Supreme Court? Legal Service Authority Act is there, and you can government will, on behalf of you, government will engage in advocate. Senior advocate will be assigned the work. And now that's LSA. Legal Service Authorities are there. The High Court is there. The Judiciary and lowest one in the Taluk level also there. And the Supreme Court is there. You can approach the Legal Service Authority for any legal advice or legal assistance, everything. Now it is improved.
My name is T.V. Sharma. I am from Rantanapur. My simple question is about this maintenance case.
Maintenance.
Yeah, maintenance. Then first is section 24 of the HMA 1925
HMB, Hindu Marriage Act.
Hindu Marriage Act. But even though the people are not adopting that old system, section 24, they are maximum adopting CRPs. 135. So why people are not adopting that one? Number one. Second, suppose if the person is not able to having any property, not having any money, not working any jail, what the option for him to?
No. This is what the law says. 125 is different from 24. 125 is different from 24.
Yes.
125 is a secular.
Yes.
This is secular. Anybody can file a 125 petition. But into HMA, only Hindus can file.
Yeah.
Muslims cannot file and Christians cannot file.
Yes, sir.
Therefore, that is different. Only there should be some litigation.
My simple question is, what the in for that? Because the person not able to pay the money. He will go at least 15 days first, then again 1 month, then like 2 months, again he gives a break, again after 3 months. Like, how long? What the in for that?
I didn't follow, sir. No, another call.
Suppose the person
No, మీరు అడిగింది ఏంటంటే 125, 24 అడిగారు కదా. 125 is different footing and 24 is different footing. 125 is immediate remedy.
Yes.
There should be some immediate remedy to the parents, children and wife.
Here the question is put, why did section 125 CRPC?
Okay.
Right. In that, the further aspect of minimum maintenance, whatever the labor charge and like this, say 1,000 rupees, 5,000 rupees like this. If the person is not able to do anything,
He has to work as a labor and he has to pay the money to the wife or children.
yes,
That is the law.
That is moral. That is the moral.
It's not only moral, it's illegal.
But the person is not able to give the money, then how?
Then he has to go to the jail.
How not, sir?
Then he has to go to the jail, sir.
Increasing the fundamental
No,
rights.
no, the object behind it is, the object is a male person who is suitably can work some work, he has to earn money and he has to pay the money to the children or parents or wife. Wife is more.
Only the wife is there.
Only if the wife is not in a position to maintain herself.
The wife is having the position to maintain it.
No, if she is able to maintain, court will not grant any maintenance.
Forcing the High Court in Allahabad, I saw that this is the judgment going on. They are forcing, no, we are getting the money. How not?
No, the thing is, the wife should be in a position, anybody, wife or children or parents, they are not in a position to maintain themselves.
Yes.
Then only the court will grant maintenance.
But suppose it's not receiving the money, how not he will go to care to stay continue 10 days, 15 days.
For that purpose, seminar is required.
But the important.
Yeah.
In fundamental rights.
What is your view on eligibility into marriages and
It's my opinion. You are
please comment on regarding LGBT marriage, adoption,
I have no opinion on that.
Okay, now I call upon Principal Keshav Memorial and Nagalakshmi, please come forward for short felicitation to sir. Shala this. Photo this. Yes, member. Please come. Photo this, please. Thank you, Madam. Now I call upon S. Chidalingaya, research scholar in the Department of Law. He will propose vote of thanks.
Role of Judiciary in India with special reference to Telangana state అనే అంశం పైన తమ యొక్క అమూల్యమైనటువంటి సందేశాన్ని ఇవ్వడానికి చేసినటువంటి రిటైర్డ్ డిస్ట్రిక్ట్ జడ్జ్ మంగారి రాజేంద్ర సార్ గారికి మరియు వివిధ కళాశాలల నుంచి చేసినటువంటి విద్యార్థులకి, ప్రిన్సిపాల్లకి, స్టాఫ్కి, అక్కడ పనిచేసినటువంటి ఉపాధ్యాయులకి, సీనియర్ రీసెర్చ్ స్కాలర్స్కి అందరికీ కూడా పేరు పేరున ధన్యవాదాలు తెలియజేస్తూ, రాజేంద్ర సార్ గారు అనేకమైనటువంటి జడ్జిమెంట్లు ఇవ్వడం జరిగింది. అవన్నీ కూడా తమ యొక్క ప్రాంతంలో లేదా తమ యొక్క జీవన విధానంలో వస్తున్నటువంటి అనేక మార్పులను, సామాజిక విలువలను ప్రతిబింబించడం జరిగింది. దానికి ముఖ్య ఉదాహరణ సార్ మాట్లాడుతూ మనకు ఒక 2 విషయాలు చెప్పడం జరిగింది. భారతదేశంలో ప్రజాస్వామ్య స్ఫూర్తిని, రాజ్యాంగ విలువలను, నేటి న్యాయ వ్యవస్థలో పనిచేస్తున్నటువంటి మెజిస్ట్రేట్ గా ఉన్నటువంటి వ్యక్తులు తమ యొక్క భవిష్యత్తు స్వలాభాల కోసం ఏ విధంగా తాకట్టు పెడతా ఉన్నారు, దాని యొక్క స్ఫూర్తిని, న్యాయ వ్యవస్థ యొక్క విలువలను ఏ విధంగా దిగజారుస్తున్నారని చెప్పేసి సార్ చెప్పడం జరిగింది. అదేవిధంగా దానితో పాటుగా అనేక పత్రికలలో సారు కాలమ్స్ రాస్తా ఉంటారు. జంబు అనే ఒక కలం పేరు పైన ఆ యొక్క ఆర్టికల్స్ లో భారతదేశంలో తక్షణం న్యాయ వ్యవస్థ చేయాల్సినటువంటి కర్తవ్యాలు ఏవైతే ఉన్నాయో వాటిని ప్రతిబింబించడం కూడా అనేక సందర్భాల్లో జరుగుతూ ఉన్నది. కాబట్టి మేమేం చెప్పాల్సుకున్నామంటే ఈ యొక్క రాజ్యాంగ స్ఫూర్తిని, ప్రజాస్వామ్య విలువలను పరిరక్షించేటువంటి వ్యక్తుల యొక్క సంస్థల యొక్క గొప్పతనాన్ని కాపాడడంలో న్యాయ విద్యార్థులుగా, న్యాయశాస్త్ర ప్రొఫెసర్లుగా, రీసెర్చ్ స్కాలర్లుగా ఈ దేశంలో సగటు మానవునికి, సగటు పేదవానికి అత్యున్నతమైనటువంటి కోర్టులలో న్యాయాన్ని అందించగలిగినప్పుడే దాని యొక్క విలువలను, దాని యొక్క స్వరూపాన్ని మనం కాపాడిన వాళ్ళమైనా అని చెప్పేసి, ఆ విధంగా కాపాడడంలో మన వంతు పాత్రను మర్చిపోకుండా ప్రయత్నించాలని, దానికోసం మీరంతా కృషి చేయాలని చెప్పేసి తెలియజేస్తూ ఈ అవకాశం ఇచ్చినటువంటి ప్రొఫెసర్ రెడ్డి ఈ యొక్క కార్యక్రమానికి స్ఫూర్తి తీసుకొని ఈ యొక్క కార్యక్రమాన్ని నిర్వహించినటువంటి డిపార్ట్మెంట్ ఆఫ్ లా హెడ్ ప్రొఫెసర్ డాక్టర్ ఎన్ వెంకటేశ్వర్లు గారికి, ప్రిన్సిపల్ పీజీ కాలేజ్ ఆఫ్ లా, అదేవిధంగా ప్రిన్సిపల్ యూనివర్సిటీ కాలేజ్ ఆఫ్ లా ప్రొఫెసర్ రాధికా యాదవ్ గారికి, విచ్చేసినటువంటి పార్ట్ టైం లెక్చరర్స్ అండ్ వివిధ కాలేజీలటువంటి ప్రిన్సిపల్స్ కు, రీసెర్చ్ స్కాలర్స్ కి, విద్యార్థులందరికీ కూడా పేరు పేరున ధన్యవాదాలు తెలియజేస్తూ సెలవు తీసుకుంటా ఉన్నాను.